The next case on our docket is Estate Azbell versus Estate of Guillereault. Each party will have 15 minutes to present their arguments. The appellant may reserve 5 minutes for rebuttal. How long would you like to reserve?
2 minutes.
2 minutes, thank you. We'll note that. I'm keeping the time up here. If you get about a minute left of your time, I'll remind you then. For initial time, for the 2 minutes, if you do that, I won't give any reminder at that point. That's a short period of time. The arguments are being recorded. When you present your argument, please introduce yourself. Keep your voice up so we can hear you, and stay behind the podium because we are visually recording you, and if we probably lose you audibly and certainly visually if you move around a bit. You should not use the name of any child, minor, or victim in this case. Make sure you use initials, I think, like we've done in your briefs, or some other designation. With that, we've read your brief and are ready to proceed whenever you are.
Hey, please the court. I am Russell Randazzo, and I am here on behalf of the estate of Rachel Azbell. We are here requesting that this court review the record before it and the underlying facts in order to review the summary judgment that was granted in favor of the intervener, State Farm. The estate of Rachel Azbell believes that the lower court erred in determining that there was no issue of material fact regarding the actions that occurred on May 19, 2019, and thereby allowing State Farm to apply an exclusion to the policy language and avoid any responsibility to defend and or indemnify the estate of Shawn Guillereault. We believe that this panel should reverse the lower court's decision and remand this matter so that it be tried to a jury. There's no question that this situation is a horrible situation. 2 people here lost their lives. Many others had their lives either destroyed, ruined, or permanently altered. Rachel Azbell and Shawn Guillereault were live-in partners, although they weren't married. Each of them brought their own children into that relationship. Shawn had 2 children of his own. Rachel had 3 children, 2 that lived outside the home and 1 AW that lived in the home. The facts about this situation start technically on May 18, 2019, but they certainly predate that. The record will reflect that through the investigation of this incident, Chief Grice did speak with the neighbors as well as go through the cell phone records of the victim and identified that this was a relationship that was strong, sturdy, supportive. The neighbors identified it as a healthy relationship supporting each other. The records in the cell phone records reflect that this was a healthy, supportive relationship. And that's in Chief Grice's deposition testimonies on page 19 and 20. The main time frame for this incident is between the hours of approximately 10 p.m. on May 18, 2019 and the early morning hours of May 19, 2019. On May 18th, Shawn and Rachel went bowling with Shawn's children. AWs did stay at home and was at the residence when they returned home. AW did testify that she was in her bedroom, that she was asleep, but was awoken by the garage door opening. She also was able to hear the garage man door open and close shut several times.
Counsel, just, I can't remember right now. How old was AW at the time?
At the time, she was a minor. I believe she was 16. She's subsequently now become of majority age.
Thank you.
She heard the man door open and close. She heard a glass breaking. She did hear her mom and Shawn, not her stepfather, but the man that she was living with, did raise their voices. She testified during her deposition that it was not anything more than they had previously heard before. She was up in her bedroom when she heard all of that. The only thing that she did not hear at any time, as she testified in her deposition on page 34, was she never heard a gunshot. The neighbors never heard gunshots. That's also in Chief Grice's deposition testimony from his investigation. What State Farm is claiming here is that there is not a material issue of fact regarding the intent for Shawn to cause harm to Rachel Azbell, and that they shouldn't be forced to defend and indemnify if a jury were to find that he was responsible for this. Alternatively, they want to have this panel apply the inferred intent analysis, trying to say that there was an intentional act that Shawn took that was intrinsically tied to the injury that Rachel sustained. What was the intentional act that Shawn took?
Well, the state has a reciprocal burden that it was not intentional. What 56 evidence did it attach to the summary judgment motion in opposition, response motion?
So there's absolutely zero evidence that says that it is intentional. There was Detective Staley,
So you're
who
saying there's zero evidence that
was intentional.
there's zero evidence it was intentional?
Yeah, because Detective Staley, who was from OBC, Ohio Bureau of Crime Investigation, testified that he did not do an analysis to see whose fingerprints were on the gun.
So
We
you're
can't
saying you're attached, in meeting your burden, you're saying the investigation that wasn't done well enough?
The investigation was completely flawed, and I believe.
How is that a reciprocal burden about it being intentional?
Well, if you look at the expert report of Mark Meredith, who was our analysis for the investigation, he identified that there was no way that anyone could identify who did what, so that Shawn actually even possessed the gun, that he fired the gun. No one knew where he was, no one knew whether the gunshot went directly into Rachel Azbell. It was a ricochet into her skull. So it wasn't even on the crown, it was on the crown of her head. It was not a direct shot. This was an individual who was trained in the armed services. He knew if he needed to and intended to cause harm and death to Rachel Azbell, he knew how to do that. He could have shot her multiple times. One of the cases that's cited by the appellee involves something like that. That's the
Counsel.
State Farm versus. Yes.
Counsel, before you get too far afield of her, Judge Lanziger's question, I think I'd like to back up a little bit and talk more about, Judge Lanziger is asking you about the reciprocal burden. Are you indicating to the court today that you had no reciprocal burden because they didn't prove that there was an issue of fact, there was no issue of fact that was intentional? Or are you saying you did have a reciprocal burden, that they did prove there was no issue of fact as to it was intentional, and then you presented evidence to show there was an issue of fact?
We absolutely proved that there's, at a minimum, an issue of fact as to whether there's intentionality or
Right,
not.
but there's different issues here, because this was all determined on summary judgment. Okay, so the Drescher burden is, they filed their motion, right?
Mhm.
And they had to demonstrate that it didn't fall within the policy because it's an intentional act. The trial court seemed to say they met that burden, right?
That's what the result was.
Okay, so I think Judge Lanziger was asking you, what then did you reply to show that it wasn't an intentional act? And so your reply as to whether it was an intentional act or not, or that there was an issue of fact, was that the investigation was sloppily done.
Because there's no way to prove any intent.
I know, I'm just asking if that's what you argued.
Yeah, that's what I'm arguing.
So your
Because
expert did not say it likely wasn't intentional?
there's no way for anyone to say whether anything was intentional, because both of the victim and the perpetrator of this issue, if he was the one that actually shot her, which we don't know that for fact, both of them are deceased. There was no investigation and no reconstruction of the crime scene. There was no testing of Rachel's hands to see if there was gunshot residue there. There was no testing of the gun to fingerprint to see whether she handled the gun, and it was potentially that it went off during a struggle. So all of those things completely negate the fact of intentionality of him, because we don't even know who retrieved the gun. We don't know who was holding the gun. They can't establish anything. We can't establish necessarily either that it was completely unintentional, because we don't even know if he had the gun.
What about the 911 call where he said he shot her?
So the 911 call.
So at least we know who shot her.
If that's how you understand the 911 call, I would request that, I believe it's in the record and I think it's available for this panel, to listen to it, because I've listened to it ad nauseum, I mean, over and over again. There's several statements that he's making where he's asking questions of the actual Kelly Bainbridge, who's the dispatcher. I did this, I'm going to jail, right? That's a question, not a statement. It's not an admission, it's a
Well, why would you
question.
go to jail if you hadn't shot her?
Even if there was a struggle and the gun went off when he was involved, he still could potentially have gone to jail. So he still could be asking that. Certainly, if he wanted her deceased, he knew how to do it. He went and retreated down into the basement and retrieved a shotgun where he was able to immediately kill himself. If he wanted and intended to cause a harm that resulted in her death, he was trained how to do it, knew how to do it, could have done it with a different firearm, could have done it by firing multiple rounds into Rachel Azbell. None of that happened here.
So aside from the expert report, my understanding is there's a
Yeah.
production of affidavits from people who knew the couple?
There's the expert report, there's the testimony from the chief of police.
Saying they had a
Right.
good relationship.
Yes,
Would that even be admissible in a trial, if we're talking about intent?
I mean, the estate's beneficiaries, the daughters, would be able to testify about certain things that were going on, trips that they went on, what they experienced, what they saw, what they heard. So there would be testimony that would be able to be admissible at a trial on that issue. In terms of the
I
cases.
recall the trial court citing prep deposition testimony or stating that the daughter who was the victim of the assault indicated that decedent defendant said he shot his wife.
Yeah, that is something that we believe that this court should, when they're reviewing all of the evidence, that it should not be something that they can take into consideration. We believe that the court, the lower court did err when it identified that that was something that it could rely upon. Certainly, admissions against interest are a separate beast, and they would be something that would not constitute as hearsay. However, it's treated very differently when it's a decedent. So under 804B5, that addresses specifically when there's a decedent. Because if it's a statement against an interest, so let's say it was a criminal defendant, and or even a civil case where there's someone saying this person admitted to X, Y, and Z, and they are alive, they can come in and testify to refute that. When there's a decedent, you're not allowed to use the statements against the state's interest. The only party that's actually allowed under 804B5 would be the estate allowing to use statements made by the decedent to refute something by the other party. Here, it's not the estate that's trying to use any statements, it's the intervener that's using it against a decedent. We don't have Shawn Guillereault here to come in and say, I didn't say this.
When were these statements made?
You have about a minute left, by the way.
Thank you. So that's another issue, very quickly, Judge Carr, is there's no way to know the order of events here. So even if you believe that the statement was made, there's no bloody footprints going up the stairs into AW's.
Well, that's not what I'm asking, maybe I'm not clarifying myself well enough, I
On May
apologize.
19th, 2019.
Yeah, but what I'm asking you is, the daughter, AW,
Yes.
when did she make the statement that Judge Stevenson is referring to? Did she make that at McDonald's? Did she make that to the police right afterwards?
It was when she was questioned by Child Protective Services. There was an interview there.
And when was that?
Within-
Immediately after?
Within a week and a half.
Okay, well, I'm just asking about excited utterances, basically.
Yeah, no, it's beyond that time frame. So it's not when she was at McDonald's.
Was that argued that it was a cited utterance and reason it should come in?
There was no argument by State Farm that it was an excited utterance, thereby allowing it in. But our
Counsel,
position
you'd be into
is,
your rebuttal time now, just so you know.
okay, we would say that there absolutely is no question, there are material issues of fact. No one can identify where, when, what happened here, and there certainly isn't any evidence of what he intentionally did, because no one can say that he did fire this gun. Therefore, we would request that this panel reverse the trial court's grant of summary judgment and remand for a trial. Thank you.
Evan Palak, on behalf of Applee State Farm Insurance. State Farm intervened in this case to receive a declaratory judgment as to whether they should have a duty to defend and indemnify the state of Guillereault. We filed a motion for summary judgment, arguing that there is no coverage for multiple reasons, exclusion, and the court granted that motion for summary judgment, and we believe that decision should be affirmed here. The facts of this case, I think, are critical. There was the deposition from the medical examiner who did the autopsy, who determined that the gun was an inch or two away from the victim's head at the time of the shooting. There is, we cited it in our brief, there's quite a lot of case law that suggests that when you have a close range shooting such as this, that can infer intent. Other evidence.
Did the medical examiner talk about the fact that because of the angle or anything, that this could not be a self-induced wound?
Well, I guess one of the questions that could come from that is this lawsuit is the estate of Ms. Azbell is claiming that Mr. Guillereault caused her death. If she caused her death, there's no coverage, there's no claim against Mr. Guillereault, there's no homeowner's policy saying, oh, well, if you shoot yourself in this person's house, there's coverage. So if we go down that road, it totally defeats the entire claim of coverage by State Farm.
So there were only 3 people at home at the time, AW, the decedent, both the decedents, and that was it.
AW, and there were 2 other minor children in the house as well.
Oh, that's right.
Yes, and they had to be extracted by SWAT.
The strange thing about this is that no one testified or it provided an affidavit or information to police that they heard a gunshot, let alone, they heard other things like bottles breaking, but a gunshot's pretty loud.
Well, in the garage, doors shut, children up in their bedrooms, to sound like colonial, up in their bedrooms, some distance away with their doors shut. Late at night, sleeping or about ready to fall asleep, who knows whether they could have heard a gunshot or not. I think the issue here is there's no question there was a gunshot. There's no question that Ms. Azbell was shot in her head. There's no question that she was found in the garage by the SWAT team and rushed to the hospital where she ultimately died the next day. So there is no question that there was a gunshot that evening that ultimately killed Ms. Azbell. The other issue I want to get into just quickly here is there's actually 2 pieces of evidence that came out from AW's either testimony at deposition or statement to the counselor a few days after. Let's set aside the statements that she made to the counselor a few days after. As a matter of fact, the trial court didn't even consider that. The trial court did consider AW's actual testimony in deposition, where she answered a direct question, and she said, yes, Guillereault told me he shot my mother. So and Guillereault saying anything is an admission by a party opponent. He's effectively a party in this case because whatever he says translates to his estate in the wrongful death matter. So he admitted to AW that he shot her mother. And that was brought out in her testimony. Yes, that's what he told me. He told me he shot my mother. The other...
Now, he says, though, that that's not, since it's a decedent, that you can't use that against him. That's an exception to the party opponent.
I would respectfully disagree. I believe the law allows for, if a party says something that becomes an admission, and then that party dies, and in his place comes the estate, that same admission that can be used against the living person who said it, the living admission party, can also be used against the estate. I think there's case law that, I think we cited that in our brief, that allows that to come in.
Was there objection to that below being used at all in summary judgment?
I believe, I think the Court of Appeals, I'm sorry, the trial court did not exclude that part of the testimony, I believe.
But there was some objection to that, the court made a ruling if it below.
Well, I don't believe it was in the briefing of the summary judgment motion, so I don't know if there was an actual ruling. I think the trial court did consider that. The other, I think, important aspect of this case is, was alluded to earlier, is the 911 call. Not only does the 911 call have, again, statements by a party opponent that can be used against the estate, he admitted to the 911 operator that this shooting, this ultimate killing, was, at the time she wasn't dead yet, so he admitted that this shooting was the result of a disagreement that got out of control. And then he also said that, I heard that 911 call too, and he said, going to jail. You can argue whether that means that he's asking a question or admitting that, yes, I'm going to jail for what I did. And then, of course, tragically, rather than facing the consequences of the crime that he knows he committed, shooting his girlfriend at a very close range, feeling that he's going to go to jail, admitting that shooting to AW, rather than facing the consequences of the crime, he took his own life. I guess the one thing that I also want to point out is the criticism of the police investigation. I know that Appellate spent a lot of time in his briefing and even during oral argument regarding some of the things that weren't answered by the police. But as we stated in our brief, the police officers alleged failure to conclusively establish where Ms. Azbell was when she was struck by the bullet, which direction she was facing, whether she was standing or seated, whose fingerprints were on the weapon, or whether there's gunshot residue in the palms of Azbell or Guillereault's hands. None of that is of any consequence here. We know what happened, not only based on the autopsy, based on the 911 call, but based on the decedent's, Guillereault's own statements. He said he shot her. He said that to the 911 operator, he said that to AW, and so I think all the other things that might be important to create perhaps reasonable doubt in a criminal case doesn't apply in this situation where we know exactly what happened. There was a tragic incident in which a disagreement got out of control and Guillereault shot Azbell in the head, ultimately killing her. And as far as the coverage law, I think once we can agree that this is clearly what the facts show, the undisputed facts show in this case, then clearly there should be no coverage for this conduct. This is for a variety of reasons. It's expected and intended injuries are not covered. It was not an accident or occurrence. You can't have coverage for willful or malicious conduct. You can't have coverage for criminal conduct. As we cited in our brief, horrible public policy to allow someone to think, oh, I can shoot this person, and whatever wrongful death suit comes out on me shooting this person, my insurance company will cover that. There's absolutely no way that can be the law. Ohioans do not buy insurance to subsidize that kind of action. So we would respectfully request that this court affirm the trial court's granting of the summary judgment in favor of State Farm. Thank you.
Thank you, Judge Stevenson. Yes, it was addressed in the motion for summary judgment below, and it was argued that it was not going to be admissible and shouldn't have been admissible. In terms of whether it was a self-inflicted wound, I don't even think that we need to go there, Judge Carr, because the deposition testimony of Dolanek, who was one of the coroner's office's representatives on page 24 through 30, identified that there was bruising on the legs of Shawn Guillereault. Where did this occur? He was coming allegedly from the inside down 2 steps into the garage. There was stuff all over the garage. Rachel Azbell's body was found right at the end of the stairs. There is an absolute possibility that he tripped while holding the firearm, accidentally discharging it, resulting in the bruising, resulting in the grazing on the crown of the head of the bullet, as opposed to something that he intentionally did.
Is the summary judgment possibility, or is it material evidence?
Well, certainly if he fell down the stairs, that's material as to whether he intentionally discharged a firearm. Chief Grice, as well as Detective Ed Saley, said firearms go off all the time accidentally. This is one of those situations where if he tripped down the stairs, and the juries believe that he tripped down the stairs with a firearm in his hand, that could explain why there was a grazing on the crown of the head right where, and it would also explain why it was in close proximity. You're talking about 2 stairs down out of a house, and the chair where she was right there. If you're falling forward because you're tripping, that is absolutely an explanation as to an accident, which would be an occurrence under the language of the insurance agreement.
I know your time is up, counsel, if you might briefly conclude.
Yeah, so the last thing about all of this is the timing of when he allegedly said something to AW. There is no...
Well, if you briefly conclude, I mean, not get into more argument.
Yeah, okay. Well, we believe that there is, at a minimum, material issues of fact as to what occurred here, which would negate the ability for the trial court to take it away from a jury to determine whether there was an intentional act or inferred intent. Thank you, Your Honors.
Court will take a matter under advisement and issue a decision in due course. When that decision is released, it will be mailed to you by the clerk of courts and also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentation today.